Part 2, I'm in courtroom Kerry Bensinger, Judge, Department 4, in the Clara Shortridge Foltz Courthouse. I'm getting ready for the pre-trial. They still haven't established jurisdiction over me, and they're doing everything against my consent. They, as you've seen in the last video, they appointed a court-appointed attorney that I did not consent to. I fired her numerous times, 5 times to be exact. The court ignored my plea for mercy. Then they entered a legal plea of not guilty. When I was asking what's the nature and the causes that are being brought against me, before you can establish jurisdiction, you have to establish what is the power that the judge can use or the courts can use over you, which he didn't do, so he reverted back to what they usually do. Violence and coercion. Violence and coercion. Like I said in previous videos, this whole thing is based on violence and coercion. It's called argumentum da ballaculum. Argumentum da ballaculum. That means appeal to the stick. That is Latin. That means back in the day, when somebody wouldn't listen to the power structure of the monarchy, they would basically force you to. That's all that's going on here. So I'm waiting for the court-appointed contender to come, and so we can get started. Good afternoon, Your Honor. Yes.
However, the court approved the file and sees that Judge Stryker previously denied your request. The court doesn't find any cause to change Judge Stryker's ruling at this time.
May I ask why, Your Honor?
Is there any good cause to change the ruling?
Because I'm competent?
It's not a question of competence.
So what is it a question of?
It's a question of your ability to represent yourself.
I can represent myself. That should be my decision, right? It's part of the rights.
Well, it certainly is your decision if you're able to understand the nature of the charges against you. But based upon Judge Stryker's...
It doesn't say that anywhere when you have a right to represent yourself. That's part of the Constitution, 6th Amendment.
I understand this.
Did you take an oath to the amendment, Your Honor?
I understand you're asking the court lots of questions, and that's okay.
Yes?
But at this time, I'm going to deny your request to represent yourself based upon your proceedings in this court, your demeanor, as well as primarily Judge Stryker's decision, and the fact that there are no further grounds for this court to revisit Judge Stryker's ruling, no good cause being shown.
So the evidence, Your Honor, is my demeanor? That proves I can't represent myself. It's my demeanor?
I've already ruled on it. So Judge Stryker found that you did not understand the nature of the charges. You did not understand what misconduct meant. You did not understand what jurisdiction this is. The court has no reason to believe anything has changed. So the request for self-representation is denied. So this is all the people do.
I didn't hear the last thing you said. According to what I understand about the court proceedings, okay, I have a 6th Amendment right to represent myself, okay? I have called you Your Honor. I called Mr. Stryker Your Honor also. I conducted myself very professionally. When I was asking about the jurisdiction, I need to know, because I have the misdemeanor advisement of rights waiver and plea form here saying that, yes, I will plead guilty and I will pay you or the punishment or whatever, but first I need to know the nature and the causes of being charged with in order that we can establish jurisdiction. Mr. Stryker wouldn't answer my questions. He kept saying, I can't give you legal advice. I can't give you legal advice, when I wasn't asking him any, Your Honor. So you're admitting to breaking the oath to the Constitution? That's what you're doing right now by not allowing me to represent myself because of my demeanor? Okay. So I just proved what we were just saying previously. That's evidence. presently in LACC College. I can verify it.
The answer to your question is yes, if you're going to go directly to the 810.
Yeah, my only concern, and I didn't address this is that I don't know Mr. Porter's schedule for the holidays, that being the law prevents personnel from Whole Foods. So if we can get a stipulation to reasonable people's continuance for his availability only, I would be fine with it 8 or 10 days.
All right. Ms. Stahl? Otherwise, I'll just set an earlier date. What's up?
Sure, my, again, my concern is that we set a clear trial that far out, if I'm not here, we can do the attorney doesn't know a clear trial date to check in.
Do you have a sense of when your time is up?
It's a bit up in the air recently, but it could be 2 months.
Well, really, it's up to you. Do you want to talk to your client about it? I'll set it for any date you want. If you set it close to the holidays, though, I'm going to grant the people's request for to have a stipulation for a reason.
I understand. Do you want to set it for trial in roughly a month? Or if you want to wait till after your finals, then what they're saying is that if they can't get their witness because of the holidays, do you want to set it right after the holidays?
Yeah,
When do your
I
final
can.
end?
I think. Yeah, I'm open in January again.
Can we do January to avoid the holidays?
That would be the worst possible time because all the cases from December are put into January.
Right. So we're not going to go that far out to January. So it's really a question of
So what about December 28th, December 30th?
Mr. Rockright. Obviously, you're represented by counsel. I answer your question. Those are exactly the dates we were worried about, as they are the holidays. So,
When
we
do
want
the
a
finals
What about
early
the-
dated, early dated December? That's fine. We want a mid-November date. That's fine.
It
We
would-
want an October date. That's fine.
The only problem is that the finals are between December 7th and the 14th. So if it could be the 15th or the 16th, that would be perfect.
We can do that, and if there's a all right, Ms. Saul, do you want to speak to your client about what he wishes to say to the court?
Yes.
I handed in an affidavit this morning. I need a confirmed copy or a receipt or a signature on something that I handed it in, please.
All right, thank you very much. So,
And I have a question for the prosecution, Your Honor.
Again, you have counsel and
It's best that you talk through me, okay?
Yeah, I want to ask him
There
why
are
was he
channels
choosing
of
to dismiss the case?
To dismiss it or not to dismiss it?
No, I was asking him why to make a decision to dismiss the case.
Why he could make a decision to dismiss
No,
the case?
why did he make a decision to dismiss the
Because
case?
I asked him to.
But he doesn't have to, right?
No, he
if
doesn't
there
have
was
to.
evidence, right?
Well, he would have accepted that as a new deal instead of going to trial.
Because you could get more time out of probation than the 6-month max of the petty
No,
crime.
no, you can't.
Well, how long is the probation max?
It's whatever the max is on the case that you're on probation for. So you're on
What is
probation
that?
for a trespass, which the max is 6 months.
Okay.
So it's the same.
So he was going to dismiss this case and then give me an additional 12 months?
Of probation.
Right, which is basically a death sentence.
No, it's not.
Yes, it is. Because
Alright,
you
but
can get,
you don't
right,
have to
if you
accept
come in
it. It was an
contact with
offer.
police, it's a violation, right?
This is your next court date. Let me check on those affidavits.
Yeah, I
okay?
have one more question for,
What is it?
how did he come to his determination for jurisdiction, subject matter?
I already told you it's automatic. He didn't come to any determination.
It's automatic with no
Automatic.
evidence?
Yeah, no evidence. It's automatic.
That's on the record, right? So no evidence? Right, it's all by force and coercion.
People versus
Okay. You're agreeing, right? Okay.
But not conduct. Good afternoon.
Oh,
And with the Spanish language interpreter, please put his credentials on the record.
Hotel also provides financial representatives, certification number 300846. We are all on
yeah, so now I'm outside of court, and I'm not sure if you guys could hear me well, but basically what happened was I
I was making the judge prove that he had subject matter jurisdiction over me, and he wouldn't answer my questions. What you couldn't hear on the recording was that nobody was answering questions. Instead of answering me, they would do what little kids do and remain silent, right? So you see the maturity level of the court system. It's the maturity level of a child, okay? And then when I question them on the own things that they've written, they try to act like I wrote them. Now, you should have heard the lawyer that was, the attorney that was forced upon me against my consent, because we all have consent here. That's why you have wills. She admitted that they don't need evidence to convict you. She admitted everything that most of us know if we just watch a news program or pick up a newspaper today, that these people are running rampant just like any other gang that they call criminals. She admitted that they're the mafia. She admitted this on tape. She admitted that they do the exact same thing as the mafia, which is make money off of coercion, off of threats, off of physical abuse. If you don't pay up, if you don't come to court, you're going to be arrested and put in jail. It's called a warrant. Okay, holding people against their will. You can't do that. This country, supposedly, what they say, was founded on the will of the people, right? But it's a misnomer now. The will of the people, or the people is the state. That's why if you notice when the judge talks to the prosecutor, he calls him the people. The prosecutor's not the people. The prosecutor's being paid by the state government just as a judge. So now you have no way of having a fair and impartial trial. It's virtually impossible. And I was trying to explain this over and over again, using their codes and statutes, using their own words, and they kept using circular reasoning. And basically, hey, I have the power. I don't have to listen to you. This is a deal. So you're not even following your own law. What exactly are you following? Okay. And they had tried to make me take a deal as well. Okay. The prosecutor was going to dismiss the case, which he should have already dismissed. The judge should have dismissed it for lack of jurisdiction, but the judge refused to hear my motions. Okay. Because they have no authority unless we give it over to them. There is no empirical evidence that just because you live in the state of California, okay, that the laws apply to you. People have to produce evidence. I can't force anybody to do anything without any type of evidence or any type of power or men or weaponry. And that's what they're doing, because they don't have evidence that it's okay to force people to do things against their will, like to go to court, to pay a traffic ticket, on and on and on. So at the end, the prosecutor was realizing this, and he went to the court-appointed attorney and said, hey, we'll dismiss the case. You know, that's no surprise because you don't have any evidence to support it. We'll dismiss the case, but, right, here's the catch. You got to take a year probation and you got to do 10 days of community service. And what do you think I said? No, it's not happening. It's not happening. Because since you can't prove with empirical evidence that I have to obey your law or the will of this court or the will of the judge, I'm not taking anything. As far as I'm concerned, even if somebody sees somebody doing something, okay, like for instance, public drunkenness, that's not a crime. Because if you look into the constitutional law and the common law, a crime consists of an injured flesh and blood victim, an injured party, an injured property. So how is it somebody not carrying an ID and gets questioned by a cop and a cop threatens him with arrest to find out who he is? The cop can't arrest you. How is that a crime? So you're telling me walking around town without your ID is a crime? Where is that written? Same with, out here in LA, there's a lot of homeless, so they have camping ordinances. So people get arrested. They call it trespassing. Where's the injured party? Has somebody destroyed property? So for instance, if somebody's sleeping in a doorway between a storefront on a public sidewalk, where is the crime? Where's the injured party or the victim? There isn't a crime. A crime would be somebody sticking a knife into somebody and killing them, because now you have an injured body, and of course you have somebody that's deceased. Okay, this is a very obvious example, but I'm just trying to give it to you. So this is what they were trying to ignore. So no, we're going to trial. So we are going to trial. The trial starts December 15th. And again, I'm going to be trying to not trying. I hate that word, try. Usually when somebody says they try, it means it's not going to get done. I am going to cross-examine the witnesses, subpoena people, and I'm going to ask the courts once again, what evidence do you have that I committed a crime? You know, according to Rule 602, which says just because somebody is considered an expert or just because somebody has a testimony doesn't mean that that's evidence that they know what they're talking about. Okay? So like I said, somebody could have seen the homeless man sleeping between the doors on that downtown city street. Okay? They call that eyewitness testimony, right? But that's still not evidence that the court system still has the jurisdiction or authority to prosecute the homeless man. First, that has to be established, because if that is established that the courts have no authority or the judge has no authority to prosecute the homeless man, then it doesn't matter what any witness says. It doesn't matter even if the homeless man was camping and that's caught on camera. There's nobody that has the power to say that this homeless man is doing wrong and he has to be punished. So ineffectually, you have people playing God. And that's why it's www.cslawinfo.us. It's www.cslawinfo.us. We don't play that crap, okay? We don't get down with that. We're fighters. We'll fight every word, every doctrine. The only thing we can't do right now is fight him physically. So you got to get into the books. It's very easy. Everything's like, there's audio books now, okay? A great audio book, and I'll plug this guy, because he's actually trying to wake up his own people that put this whole system in place that's abusive and corrupt. And his name is Mark Stevens, okay? His name is Mark Stevens. You can go to markstevens.net, and he wrote a book called Adventures in Legal Land, which is basically saying all the legalities are based on fantasy. It's based on somebody's vision or idea on how reality should be. And all of us have that power and capability if we really think about it. So what I'm saying is, if you don't have the will of the people's consent that you supposedly represent, how are you operating your system? You're operating it by force. You're forcing the people to consent. And that's not, in reality, that's not the people letting you rule over them. You forced it on them. And that's exactly what's going on now. So we'll have updates. I'll have an update with this public defender woman. And I'll keep you updated, because I had to school her. She at first was trying to tell me I didn't know what I was talking about, and then I had to tell her over and over again, I have the definitions right in front of me. How are you going to tell me that what I'm talking about is not correct? I'm not making this stuff up. It comes out of your own books. Okay, so now this is ego and pride, and people usually hang themselves with it. How do I know? Because I have experience. It's happened to me. So I don't use my ego and pride anymore. I make sure, even if it's 5 a.m, I'm dead tired, I find an answer to what I'm looking for, so I know what I'm talking about, okay? And then you guys should know from watching the other videos, you can check us out on YouTube at Private Attorney Generals, or just go to the website, www.cslawinfo.us. Go to contact us. It'll take you all the way to the bottom of the page, and you'll see the buttons for LinkedIn, about the business. You'll see YouTube, you'll see all these plugs. Hit the YouTube and you'll see a bunch of videos. You already know by going to our videos that in these law schools, they're not teaching them what the legal definitions are. They're teaching them interpretations, okay? And that's what she tried to say. She tried to say that subject matter jurisdiction is the same as personal jurisdiction, and they're both combined in a criminal court. That's incorrect. The judge has to prove subject matter jurisdiction because the subject would be what the person is being charged with. The matter is the facts, or matter of fact means the same thing. And then the jurisdiction. Does the court have the power to prosecute? Okay? And without these three things, they can't proceed forward. But what normally happens is the judge turns to personal jurisdiction, which basically means that the courts are allowed to have jurisdiction over parties or property, okay? And you're neither. If you're by yourself Without co-defendants, you're neither. And even, that's even besides the point, okay? That's even besides the point, because you can't claim personal jurisdiction in a criminal court. At least in the charges that were going on in my case, like the trespassing, okay? And if you look everywhere now, you can be in the store parking lot, and if you don't want to leave, they say you're trespassing. Even though it's your earth too, and just because somebody says that's their property. And that's the reason why everybody was fighting back in the day. They had to make laws, or supposedly laws, to make sure that they wouldn't get attacked anymore, because they were doing all the attacking. So first, you know, the Europeans came, they conquered, and then they made laws so you can't conquer them back. When in reality, if they would have just came and minded, you know, their business and did what they had to do and respected other cultures and people, we wouldn't be in this which Mark Stevens talks about all the time. We wouldn't be in this terror storm or this hellstorm where people are obeying a corrupt, sick system. You understand? So go to the website. It's www.cslawinfo.us, www.cslawinfo.us. You can find out lots of information. We have information packets, about 10 of them. What I just talked about, you know, but we have jurisdiction, information packets. We have what's the difference between common law and statutory law. You know, what is a private attorney general, private attorney generals versus lawyers and attorneys, on and on and on. Some of the packets are 5 pages, some are 10 and up. Anything over 10 pages is $10. That's it. So if the page is 19 or 20 pages, then it only costs $10. Okay? And this is information you're not going to find in the schools. This is information that your court-appointed attorney or your hired attorney is not going to tell you, because once you hire somebody else, you've given consent. Okay? It's called implied consent. It's the same as when you don't show up for court or you don't give a response when they're talking to you. They look at that as implied consent. So you always got to keep challenging. You always got to keep talking, okay? And don't hire a lawyer. Don't hire an attorney. Stop being afraid. Put in the time. Listen, if this was the 80s or 70s or 60s or 50s, it would take a lot more work and effort to represent yourself. Today with the internet, you can find information that took years, that took decades to come. You can find it within seconds, so there's no excuse. And if you don't own a computer, go to a public library, and you can use a computer for free for a couple hours. That's all you need. You just need, even if you put in 20 minutes to a half an hour a day, every single day, for a year, you'll have more knowledge than most, okay? So stay tuned, and look forward to trial.